Hello, hello, hello. This is attorney Mike Gravlin. I've been having everybody ask me to say my last name slowly. Gravlin. That's my last name. We got some fun ones today. Oh, I'm small here. There we go. Let's see my big noggin. All right, I got some fun clips today. The first one's a short soft sit that I poached from Van Balen because, well, I haven't done that for a while. Then I've got a new judge to the channel, Judge McBurney. He's really pretty cool. He strikes me as a pretty sharp judge. He's kind of an intellectual guy, and he's got a sense of humor. That's an interesting clip. And then we're back to Kansas, and the judge, I can't remember his name now. I think it's Gutler. Whatever, the bow tie judge, the young judge with the bow tie. He's a lot of fun. So let's get her all started here, shall we? Let's do this thing.
You're either Christopher Cavalcanti or you are not. I just need an answer to that question.
I am the authorized administrator and beneficiary of the accounts, Christopher Cavalcanti.
Thank you. It seems that we're going to be going around like this for a while. So since I am unable to determine whether or not you are Christopher Cavalcanti, the bond is forfeited. I'll issue a bench warrant for Mr. Cavalcanti's arrest in the amount of $15,000.
Your Honor, I would like to actually object to that.
The objection is overruled. The case has been called. It's over.
I love that, Your Honor. I would like to object to that. It's overruled. That's a thing of beauty. It really is.
There's a bench warrant for Mr. Cavalcanti's arrest. Next case.
Can you please explain to me what that means?
It means there's a bench warrant.
So are you trying to deny me justice, Your Honor? I'm simply here regarding the matters of the case.
I know who you are. You refuse to tell me who you are.
Oh, I have identification.
Stop interrupting me.
All right, Mr. Hill, you are once again unmuted. Appreciate your patience. We are going to turn now to your case. Ms. Rivers, good afternoon. You ready?
Okay, so this is Judge McBurney. We never get to see him because the camera's always pointed away from him. I've seen a couple other clips from him. Like I said, he's a pretty intelligent, good judge. And he just throws in like little, they're appropriate, they're not edgy, but he throws in little jokes all the time that are actually pretty funny. He's a witty guy. I believe he is in Georgia. That is my belief. But if I have that wrong, please tell me in the comments.
Yes, Judge, I'm ready. Good afternoon.
This is 22 SC 182098, State versus Kenneth Carl Hill. Mr. Hill is represented by Ms. Wood. Ms. Feely is the lead attorney on it. She's not available today, but her trial partner, courtroom partner, Ms. Wood, is here on her behalf. Ms. Feely filed a motion about a week ago. We're moving fast. And it was to reconsider bond. Ms. Feely pointed out that Mr. Hill has been in custody without bond on some pretty serious charges, but they're merely allegations at this time for almost half a year. And she thinks it's time for me to think. Well, now the number went up in her motion. It's either half a year or 3/4 of a year. Either way, it's a long time. And so it's time to think again about whether bond is appropriate for Mr. Hill. Mr. Hill, I will hear from Ms. Wood, then I will hear from Ms. McCauley, the prosecutor who is handling the bond hearing. And I'll let you know, most likely, right now what I'm going to do. Ms. Wood, when you're ready.
Thank you, Judge. Mr. Hill has been in Fulton County Jail since January 25th of this year, which is right at 170 days. He is in no bond status. We're asking the court to consider a reasonable bond in this case. He is 33 years old, Judge. He is single with one son, 11-year-old Noah. He's officially a resident of South Carolina. He tells me that his hometown is about 2 hours from here. He lives there with his mother, Tina, who, if he is granted a bond, she would be the primary person to bring him to and from court dates, Judge. He has lived at that particular address for the past 4 years. He has a 10th grade education. He was most recently employed as a cook at IHOP. According to the notes I have before me, he has no violent history or other history that's related to these type of charges. He reports he has no failure to appears. He's not on probation or parole. It looks like he was last heard before a court, I think it was this court, on February the 15th, where bond was denied. The basis for Ms. Feely's filing of the motion for reconsideration was at the time of her filing, he was housed on 6 South. Our office is gravely concerned about what's going on at the jail currently with their conditions, Judge, particularly on 6 South. I'm sure
This is good because the attorney's doing a nice job of trying to say it's not safe for my precious little client, which is her job, and she's doing a great job of it. But he undercuts it totally later in this hearing. And I the other thought I had is he happens to be a cook at IHOP, and as soon as they said that, I thought, I bet there are a lot of convictions back in the kitchen at IHOP. just a guess. Just a guess.
Sure the court is aware of the number of cases that are coming in at first appearance regularly stemming from stabbings and other fights and different violent interactions that are happening at Rice Street, Judge. So that is the reason that she refiled. We are just asking the court to consider a reasonable bond in this case.
Thank you. Did Mr. Hill's job at IHOP was a job in South Carolina or down here?
I believe it's South Carolina. Is that correct, Mr. Hill?
Yes, ma'am.
Okay. I think I remember this case. It involves like the Greyhound bus station and 2 young ladies in one of my areas of concern. And I'll hear from Ms. McCauley, but then I'll circle back to you, Ms. Wood, is what the heck was Mr. Hill doing allegedly down here in Atlanta? And then there were these young ladies on a bus, et cetera. And so the lack of connection to here that made me a little reluctant on the bond front. It sounds like there are maybe some sources of stability in South Carolina, which is an adjacent state, but it is not the state of Georgia. Ms. McCauley, what's the state's view? Well, one more question for Ms. Wood. Ms. Wood, are you able to tell from your review of the file, that is Ms. Feely's file, if there are any discovery issues or any reason why what we ought not to do is just make sure we get Mr. Hill into court pronto for his trial?
Judge, I did speak with Ms. Feely yesterday, and from that conversation, it seems like she has most of her discovery. Of course, I don't want to say for certain that she has everything, but I am confident if there's any issues, we'll get with Ms. McCauley.
Okay. Or Mr. Shapiro.
The judge tips his hand right there, and in the best way possible. It's the exact thing I'd be thinking if I'm a judge. We're getting near trial. Why would I let this guy go to South Carolina, which is, albeit close, it's not like that's so strange in and of itself. So he says it's about 2 hours away, this town where he wants to go. But why am I letting this defendant facing serious charges into another state just prior to trial? And if I remember right, the prosecutor says not no, but hell no.
But importantly, Ms. Feely did not tell you, I don't have my client's statement, and the 2 young ladies went to the Center for Children's Wellness. I don't remember what it's called anymore. That one. They went there and they gave one of those forensic interviews. That's not what Ms. Feely told you.
Correct, Judge. She did not tell me she was missing anything.
Okay, got it. Thank you. Ms. McCauley.
Yes, Your Honor. The state is opposed to a bond at this point for this defendant. He does not meet the criteria under Ayala in order to be considered a viable candidate for bond. So just to summarize, the court is familiar with the facts of this case. The 2 young girls, they were 14 and 15, ran away from Forsyth and ended up at the Greyhound bus station in Atlanta, where they were denied the purchase of tickets based on how young they appeared to the teller. At which point they encountered the defendant, then took them back to a car wash where he said he worked at, and provided them with alcohol and weed, and then proceeded to have sex with them. In the interim, since this case has been indicted, a codicit did come back matching the DNA in one of the juvenile victims, a sexual assault kit to the defendant. There's a confirmation of a swab pending right now at GBI. It does look like it's in process. So that is an outstanding matter of discovery for the court's information. But obviously that changes the stakes as it relates to Mr. Hill and the charges against him and how soon he needs to be brought to trial. That's a pretty significant development in the state's opinion in the terms of this case. And does obviously go to this defendant's flight from the jurisdiction. As it relates to his criminal history, he is actually on probation out of South Carolina. There's a shoplifting case that he received 5 years and 18 months on probation for back in 2020. He also has 2 pending other cases. One is out of Pickens County, South Carolina, for a breach of the peace. That's manufacture, possession of Scheduled 1. In the first degree, which apparently is a felony offense. It's also drugs and distribution, sell, manufacture, or possession with intent to distribute near a school. That's a pending case that he has. He also has a pending case from 2021 from Anderson County, South Carolina for petty larceny. And just as I know Ms. Wood is standing in for Ms. Bailey, and she may not be familiar, but this defendant also does have an arrest from 2015 for criminal sexual conduct in the second degree. I can't see the disposition on his GCIC, but obviously that is.
Okay, he's naughty boy. He's naughty boy. We've basically got a couple different incidents of SA at least that he's been caught for. We've got larceny and we've got drugs.
Concern of the state, even if it was dismissed, it would be a concern of the state. As to this defendant's likelihood to commit additional felonies pending trial and his risk to the community. Certainly the 2 open cases pose a risk to the community and also indicate that he is likely to not return to this court if he were to be released on a bond because he hasn't bothered to return to those courts in South Carolina where he has his cases. So based on that, Your Honor, we would ask for a bond to remain in a no bond status.
2 questions. You said a CODIS hit, which to me usually says some other old case. Do you mean that there is yet another potential sexual assault, or CODIS was for you, there appears to be a DNA match between a swab taken from Mr. Hill and material gathered from one of the alleged victims in this case?
It's the latter, Your Honor. He did come back in the CODIS, which is Combined DNA Index System, as a convicted felon. He is a convicted felon out of South Carolina for 2017 shoplifting conviction.
Okay.
Felony shoplifting conviction, and that DNA was in the system and matched to our
Okay. So there was DNA not necessarily swabbed in this case from Mr. Hill that was the supposed match.
Correct. The girls' DNA or sexual assault kits were analyzed by the GBI. A male DNA hit came back in one of them, and then it hit to the CODIS.
Okay. Of all the DNA in the nationwide CODIS system, it came back to Mr. Hill's.
Correct.
Got it.
That pending confirmation swab, or that confirmation swab is pending.
Got it. Okay. That's helpful. Second question, you mentioned something to the effect that Mr. Hill didn't come back to court for his 2 open cases, drugs and larceny in South Carolina. Are you saying that because he's been stuck here, or there are failures to appear in the system?
I'm saying that because those cases are still open in South Carolina.
Okay.
I don't see any failure to appear as issued on his GCIC.
Okay.
I don't know if that translated from South Carolina.
Yep.
I'm going to check right now and see if he's got a hold. He does not have a hold out of South Carolina, so it may just be non-extradition. But I see that those cases are still open in those South Carolina dockets.
Okay. Do we have anyone from pretrial services on the call? Oh, okay. Ms. Wood, you and I both didn't know about, well, at least I didn't know about the CODIS development, not necessarily a favorable development for Mr. Hill, but our assessment right now is it a strong case or a weak case so much. That's just helpful to learn about. One of the things that has changed is maybe not something real favorable for Mr. Hill. Was there anything you wanted to add in connection with Ms. Feely's motion?
Judge, I don't believe so. I did not realize that he was on probation. So thank you, Ms. McCauley, for adding that so I can have it for my notes that I give back to Ms. Feely. I just think Mr. Hill understands, Judge, that this is a very serious case. And so we'll just ask the court to consider the reasonable bond, but he does understand the position.
Sure. Mr. Hill, I appreciate you listening in on all this, and I understand your predicament. I'm not going to change your bond status because two things. One, I'm looking at the scheduling order, and we have your case moving along. Tomorrow is the deadline for Ms. Feely to file any motions. If she thinks there are substantive motions, like suppress your statement if you gave one. I'm not saying you did. Things like that. There aren't any in the system. We've got a date to hear the motions coming up in just a couple of weeks, if any are filed. And then we've got you just a few weeks after that on a status conference, which is sort of a final plea date where I make sure everyone's got discovery. Is this case working out? Or should we try it? We even have a trial date for you that's just a couple months down the road. I think that's where your case ought to go, and that's what I'm going to do. So I feel like the case is moving at a fairly healthy clip. I appreciate that each day it's your day in jail and not mine, so it may not seem like it's moving all that fast for you.
This is where I think that the judge has a cool vibe. He is thinking, hell no, you are not getting out. I am not letting you go where near trial, and you are a danger to society. But since he's made that determination, he's real nice and upbeat in the way he delivers it. It almost sounds like it's a good thing. The way he's so peppy when he says it.
But it is. The second thing I'll do is see if we can get you transferred to the Cobb County Jail, because there isn't much more that needs to happen with your case until it's time to get ready for trial. And so if the sheriff is willing to make that switch, that will get you off 6 South. But I can't guarantee that. I can just make the request. Sometimes it's honored, sometimes it's not. Ms. Wood, anything else on behalf of Mr. Hill?
Judge, I think he's wanting to speak to you. He did inform me when we did our breakout session that he's been awarded the status of honor inmate. So I think that's why he's in a different color jumpsuit. So I have a feeling he's about to tell you something related to that. Mr. Hill?
Okay. Sure. Mr. Hill, what did you want to share? You may not want to go to Cobb. You may just want to get off of 6 South.
Your Honor, I was just wanting to let you know that I'm in the honor dorm now on 6 North, and it's a lot better over here.
Oh, okay. So maybe leave you be. It's in a space. It's
Okay, so that's where I came up with the thumbnail. I still don't know what he said. I listened to it 5 times, but I think he said I'm in the honor dorm, and the judge sort of echoes that later. And he was really, really excited. He's like proud of this. Like I don't know how you get in. It's sad and it's kind of funny at the same time.
still jail, so it's not where anyone wants to be, but it is a step up from where you've been.
Yes, sir.
Okay.
Yeah, I hadn't even met with my attorney.
So you had a transition. Your attorney, Ms. Feely, is new to this courtroom. She is not new as an attorney. She is not new as a criminal defense attorney. She's been doing this for many years, but she recently transitioned into this courtroom. So she will come meet with you. She needs to do that so that you guys can connect and begin to figure out what the right way forward for you is. And I'm sure Ms. Wood will pass on my request to Ms. Feely that she come see you. Of course, you're not her only client, and so she's doing some triage. She was getting ready for a trial that actually we should be in the middle of right now, but she got the charges dismissed against her client. So she will be out to see you soon. I will not try to get you moved to Cobb because it sounds like you're in a better spot. But I will continue to move your case along at the healthy clip it's moving. Ms. McCauley, anything else in Mr. Hill's case?
Nothing from the state.
Thank you for parachuting in. Mr. Abate thanks you as well.
I think it's good.
All right.
Who represents the state on a case that was suspended?
Cassie Hall. It was a Whitenauer matter, and Farouk. No, not the ag stalking. That one, they dodged a bullet because the defense attorney might be saying, "You really want this continuance?" He said, "Sure, we'll do a continuance." So that one survived. Farouk was a alleged ag sodom. It was a commercial relationship that didn't end well, and I was told it was null prost.
I'm just curious.
Okay. No, it was a couple days before. It was a couple days before. All right, Mr. Hill, you are free to go. Thank you.
Thank you.
Thank you, Judge.
It's like a secret amongst you guys when that stuff happens? You have to learn it from the judge? Okay. I've never heard of the honor dorm. I wonder if it has like locks that work. It's a new thing. Maybe we could tour that. I'm happy for Mr. Hill that he got in there.
And don't forget to hit like and subscribe, or the dogs get it.
Mr. Andrus?
All right, this is State of Kansas versus Donald Andrus. Case numbers 2020 CR 346 and MGI 22 CR 230. Mr. Andrus appears in custody via Zoom with, but separate from counsel, Mr. Lamson and state by Ms. Montgomery. And these cases are set this afternoon for 1:30 in-person hearings, admission denial in the 2020 case, and preliminary in the 22. However, the court has received a plea petition that does resolve the new felony case 22 CR 230. Mr. Andrus, have you discussed your right to a preliminary hearing with Mr. Lamson?
Your Honor?
Yes, Mr. Lamson?
I'm sorry. I meant to cut this one out. It's actually kind of amusing. He just can't hear. That's all. And I just was watching the judge struggle with it, but he gets to the right place.
My client's very hard of hearing.
And I understand that. I'm not sure if he didn't hear if there was an audio glitch in the jail as well. Mr. Andrus, I'm not sure if you heard me. I'll repeat the question in the event you did not. Did you discuss your right to a preliminary hearing with your attorney, Mr. Lamson?
I'm sorry.
Did you discuss it with your attorney?
Yeah. Yes, sir.
And you understand that if the preliminary hearing were to go as scheduled, the state would be required to present some evidence to support the felony charges against you. Do you understand that?
Yes, sir.
And knowing that right, is it your decision to waive your preliminary hearing today?
Yes, sir.
All right, the court will show that Mr. Andrus has made a knowing and voluntary waiver of his right to a preliminary hearing. In order to accept your plea now, Mr. Andrus, I need to ask you some questions, and to do that, I need to place you under oath. If you'd raise your right hand for me, please.
Sorry.
Can you raise your right hand for me, please? Do you solemnly swear the statement you make during the course of this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And do you further swear and acknowledge that you have read and discussed each and every part of this document and the answers that appear therein are true and correct, so help you God?
I haven't heard a little bit of that, but I ain't heard all. I'm sorry.
Do you swear that the answers and information contained in the plea petition are true and correct, so help you God?
Yes, sir. Yes, sir.
Your answer was yes?
Yes, sir.
All right, Mima, put your hand down.
Okay.
All right, counsel, I hate to interrupt this. I think with Mr. Andrus's difficulty hearing, this can be much better done in person.
That'd be fine, Your Honor.
We're going to take this up this afternoon as originally scheduled. That will give the court some better assurance that Mr. Andrus is actually able to hear and understand everything that I'm explaining and reading to him. All right?
I'm going to be there anyway, Judge, so that's fine by me.
All right, Mr. Andrus, we'll see you at 1:30 in person. All right, Mr. Hoffmeister.
Can we start with Robert Martin? He's in my office. I'll go get him.
We can.
I actually used to wear bow ties back in the day. I don't know what I was thinking. But it looks good on him.
All right.
This one is actually pretty interesting.
All right, Mr. Martin, if you remove your hat for me, please.
Cars, that's exactly
Move your
what I
hat,
said.
Robert.
Thank you. This is the state of Kansas versus Robert Dean Martin Jr. MGI 22 CR 253. Mr. Martin appears by Zoom with counsel, Mr. Hoffmeister, and state by Ms. Montgomery. This case is on today to select a preliminary hearing date. However, the court did just recently receive a plea petition that would resolve this matter to a plea of no contest to an amended information charging Mr. Martin with 3 counts of assault, Class C person misdemeanors. Is that correct, counsel?
Yes.
All right, Mr. Martin, in order for me to accept your plea, I need to ask you some questions, and to do that, I need to place you under oath. If you'd raise your right hand for me, please. And in this oath, I'm going to make reference to the word document, and when I say that word, I'm referring to this document, the plea petition, that I believe you reviewed and signed with your attorney, okay?
Yes.
Do you solemnly swear the statement you make in the course of this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
And do you further swear and acknowledge that you've read and discussed each and every part of this document, and the answers that appear therein are true and correct, so help you God?
Yes.
You may put your hand down. You are Robert Dean Martin Jr.,
Yes.
and you are 41 years of age,
Yes.
and you completed 10 years of schooling.
Yes.
Because you're awesome.
I do have before me a plea petition formally titled Defendant's Acknowledgement of Rights and Entry of Plea. There's a signature on page 6 above the typed name Robert D. Martin Jr. Is this your signature, Mr. Martin?
Yes.
And did you have an adequate opportunity to review and discuss this plea petition with your attorney?
Yes.
And you understand the state is going to file an amended information that charges you with 3 misdemeanor counts of assault. Those are Class C person misdemeanors that carry with them a potential sentence of up to 30 days in the county jail and or fines up to $500. You understand that?
Yes.
Do you understand that by entering a plea in this case, you'll be giving up or waiving a number of rights? Those rights include
Yeah, seriously, defendant. Thanks for representing Chicago there. We're really happy about that.
the right to a jury trial, the right to cross-examine the state's witnesses, the right to take the stand on your own behalf or decline to do so, and the right to appeal everything except the sentence imposed.
Yes.
Do you believe that Mr. Hoffmeister has done a good job explaining to you the rights you'll be giving up today?
Yes.
And do you believe he's handled your case in the appropriate manner?
Yes.
Do you understand that by entering a plea, you'll be waiving the rights recovered as well as those contained in this plea petition? There will be no trial. You will give up any defenses you may have had, and you'll be found guilty of these 3 counts.
Yes.
The plea petition reads in paragraph 5 on page 2 that the state will file an amended information charging Mr. Martin with 3 counts of assault, Class C person misdemeanors. Defendant shall plead no contest as charged to the offenses contained in the amended information. The party shall recommend standard costs and fees, a 60-day jail sentence, and for immediate suspension of said jail sentence for a period of 90 days. If defendant pays all costs, fines, and fees within 90 days, the case shall terminate. If defendant fails to pay within 90 days, defendant shall serve 60 days in jail. And the parties recommend that defendant's outstanding bench warrant be withdrawn. Which I'm glad that was in there. That's something the court wished to address. Mr. Martin, you are currently out you were out on a medical furlough. You were instructed by the court to provide documentation that that medical furlough was still necessary. You failed to do that. Consequently, a bench warrant was issued. We received the facts, but it did not indicate that your medical furlough was still necessary. It just said that you saw a doctor. And so a bench warrant was issued for your arrest. Your medical furlough was withdrawn. I do have a note here from the clerk that indicates that your mother called on June 27 and you were present during that phone call, and that both you and your mother were aware that you had a warrant. Is that correct?
I wasn't aware of warrant
When did you become aware that you had a warrant for your arrest?
today.
Hang in there, BB-8. You'll get it done.
You weren't present with your mother when she called the clerks on June 27th?
Hearing about that, my short-term memory goes and comes. I don't remember it.
Did you sign this plea petition today? All right. This says the 14th day of June. I presume that's supposed to be July then, counsel?
It is, Judge.
All right. I'm going to strike June and write in July.
Again, this hearing I just find interesting. You really get to see it. They go through the plea process on a complicated thing, and there's a suspended sentence and other issues that come up, and then we go straight to sentencing. The attorney, I think, handles it really well. The judge is very straightforward and does a good job. And the defendant, he doesn't fight it. He does roll with it in his way.
Thank you.
All right, Mr. Martin, do you understand that the court is not bound to follow the agreement you reached with the state regarding the sentence to be imposed?
Yes.
At the time of sentencing, which take place here shortly, that I can impose the maximum legal sentence that I feel is appropriate for these 3 counts?
Yes.
With the exception of what's contained in the plea agreement, have any promises been made to you to enter a plea today?
No.
Have you been threatened to enter a plea today?
No.
Do you suffer from any disability that prevents you from understanding your rights or what's occurring today?
No.
Are you currently under the influence of any alcohol or drugs? I didn't hear your answer. I'm sorry.
No.
All right. Do you have any questions for the court or your attorney at this time?
Sir.
With all that information in mind, then, how do you plead to amended count 1, assault, a Class C person misdemeanor occurring on June 5th, 2022 in Montgomery County, Kansas?
No contest.
And how do you plead to amended count 2, assault, a Class C person misdemeanor occurring on June 5th, 2022 in Montgomery County, Kansas?
Contest.
And how do you plead to amended count 3, assault, a Class C person misdemeanor occurring on June 5th, 2022 in Montgomery County, Kansas?
Contest.
All right, Ms. Montgomery, provide a brief factual basis, please.
This is good. Since he pled no contest, they need a factual basis, and the factual basis is short and sweet, but it's kind of funny.
Yes, Your Honor. On June 5th, 2022, officers were dispatched to 215 East 10th Street, apartment 9B in Caney, Kansas, which is within Montgomery County, in reference to an assault. When they arrived, they made contact with Melinda Rush, who stated that Mr. Martin began yelling at her and a Leanne Mock that someone took his phones out of his room. And he yelled that someone also took his tobacco out of his room. And then he told them he was going to kill his brother for stealing his stuff. Then he called Ms. Rush a whore and told her to leave while holding a baseball bat, which put her in fear that she was going to be hit, Your Honor, all within the statute of limitations.
Okay, so I think what we've learned here is you don't touch this guy's stuff. I'm sorry. He just pled guilty to it. He'll be punished for it. It's the factual basis was funny.
All right. And so is the state alleging that the other individuals that you mentioned in that recitation were also victims of assault? Giving 3 counts?
Yes, Your Honor. Well, what we did was this was a move or part of the plea deal. It was an ag assault because of the baseball bat, and we knocked it down to 3 assaults, Your Honor, due to the baseball bat issue. However, there were questions about how threatening his stance was when he held the baseball bat.
All right. And Mr. Martin, are you acknowledging, admitting that there would be sufficient evidence for the court or a jury to find you guilty of 3 counts of assault?
Yes.
All right. The court then will find your no contest pleas were knowingly and voluntarily entered into, we find a factual basis to support those pleas, they'll be accepted, and I'll find you guilty of 3 counts of assault, Class C person misdemeanors. We will advance to sentencing. The party has, or the court rather, has the party's recommendation and agreement. Mr. Hoffmeister, anything you wish to the court in support of that agreement?
Judge, there was an altercation in the home. There was circumstances that I believe made it reasonable to reduce this to 3 counts of misdemeanor assault to resolve this matter and not require any further hearings. Mr. Martin has minor children. They play baseball. He was cleaning his room during this argument. But I think this is a good middle ground for both of the parties, the state and defense here. Mr. Martin has the ability to pay within 90 days. I believe that it's a more appropriate resolution than supervised probation. In regards to the outstanding warrant, I was not aware of that until I did prepare the plea form this morning. I communicated.
Pleading guilty, you say you're guilty. No contest, then that's why you need a factual basis. So if you're pleading no contest, the judge is going to find you guilty, but he needs a factual basis. If you've pled guilty, you've admitted it, and there is no factual basis required. It's no contest is very close to pleading guilty, but not quite, is the best way I can say it in this brief period.
With Ms. Montgomery yesterday regarding a potential resolution. So I believe that this plea agreement should be followed, that is fair, just, and reasonable, and I would ask that you follow the same.
All right. Thank you, Mr. Hoffmeister. Mr. Martin, anything you wish to tell the court in consideration of your proposed sentencing?
No, sir.
And Ms. Montgomery, are you aware of whether the victim or victims intended on addressing the court today?
Your Honor, we have not heard from the victims. Oh, wait, we do have a victim impact statement, but we reached out to them yesterday and we were unable to make complete contact.
And the state is, I presume, joining in on this proposed sentence?
Yes.
All right.
I will say that per the victim impact statement, Your Honor, the victims indicated that an other for his punishment, that Mr. Martin would not have done this prior to being shot in the head in October, and they believe that was really what caused this incident.
All right. Thank you, Ms. Montgomery.
Yeah, I missed that on the first walkthrough, but that's, wow. Wow, that sucks.
All right, Mr. Martin, it is the judgment of the court. Your sentence will be as follows. For the offense of assault, a Class C person misdemeanor, amended count 1, I'm going to sentence you to 30 days in the Montgomery County Department of Corrections. For the offense of assault, a Class C person misdemeanor in count 2, I will sentence you to 30 days in the Montgomery County Department of Corrections. And for the offense of assault, Class C person misdemeanor in count 3, we'll sentence you to 30 days in the Montgomery County Department of Corrections. I will suspend those sentences. Order they run consecutive, however, for an underlying sentence of 90 days. And we'll suspend it for a period of 90 days, in which time you're ordered to pay the following: court costs of $158, a fingerprinting fee of $45, a bids application fee of $100, and attorney's fees of $175 per the agreement. Provided you pay all those costs and fees within 90 days, you will not have 90 days to serve in our jail, and your case will terminate. But should day 91 arrive and our records reflect you have not paid the total of the cost fees assessed today, there will be a warrant issued for your arrest and you'll have 90 days to serve. Any questions about that? We will give you credit for time served toward your underlying 90-day sentence. Does counsel know how much time Mr. Martin spent in jail on this matter?
No, not yet, Your Honor.
Do you know how long you were in jail before you got a furlough?
I don't. Not quite 24 hours.
All right, we'll make sure you get proper credit towards your underlying 90-day sentence, Mr. Martin, in the event you have to serve it. If your attorney and Ms. Montgomery kind of agree on what that credit is, that can come back before the court for a final determination. You may, in the future, have the right to have these convictions expunged or removed from your record, and you have 14 days to appeal the sentence that's just been imposed. And if you cannot afford an attorney for that appeal, one will be appointed for you. Any questions regarding your sentence, Mr. Martin?
No.
All right, get those costs and fees paid within 90 days. Good luck to you.
Thank you, sir.
Judge, let me lead them out of the office, and then I'll come right back.
All right.
Well, there you have it. I just thought those were fun. I really like the Judge McBurney, the new one. This guy hits his second. His name was on there too. Was it Gellert? I can't remember his name. I'm just going to call him the bow tie judge. But you can't really do that because there's a lot of judges who go bow tie. I had a bow tie phase, let me say. I just went through a phase for a few years where I would wear bow ties, in the mix. This back in the day when we had to wear a suit every day and a tie every day. And I think my thought process at the time was, let's mix it up. So, oh yeah, and I'd tie them. I'd tie them myself. But they're a little fussy. It takes a little more effort to tie a bow tie. It's just that they're small, so you got to do that stuff. But that was interesting. He did that. He admonished him on the whole thing. He says, "Look, I'm not bound by the plea agreement," but then the judge does follow the plea agreement. I thought that one was interesting. Mostly, the only thing that was funny or interesting about that was the factual basis. The prosecutor was like so straight face. And the incident was just like, he's like, "Hey, don't touch my stuff." And they did. Okay, they crossed him. But then you can't react like he did. He didn't calibrate. He didn't calibrate properly. So that's going to get you a criminal charge. They reduced it from an ag bat. It'd be aggravated because he was using a baseball. That'd be an aggravating factor. So, and if an aggravated battery is going to be a much more serious charge. But very typical that you're going to plea plea on ag bat as a battery, unless someone really gets hurt or something like that, and then it's too much. But that's a common plea arrangement in that circumstance. I think it was warranted. I think all that makes sense here. Thank you, whoever gifted me a membership earlier. I was late coming in and I just saw it. Thank you. Secret McSquirrel has been doing that, and I think some other people have. Somebody mentioned, I think Secret McSquirrel did, that there should be some way for me to see that, but I don't get a notification. Whoever's gifting other people memberships, thank you very much. I really appreciate it, but I don't have any notification of it, so I don't know who it is. All right, and then there's one back here I wanted to get back to. Janet, this is just, I just don't want to interrupt the flow of it. First of all, I'm very sorry. That is just awful. That is just awful. Secondly, no, there's no such thing as a pro bono medical malpractice lawyer. Medical malpractice in Illinois or in most other states, you kick it off by filing an affidavit from a doctor saying that it's a meritorious claim. So the attorney's $5,000-$10,000 out of pocket and 20 hours of reading the day they file it. So, you also don't need one because they work on a contingency basis. So if you're looking for a medical malpractice attorney, call my office. I'll talk to you about it and set you up. Or if and they don't need to be in Western Illinois, even if it occurred in Western Illinois. Just trust me on this. There might be some good ones out there, but who knows? Very specialized. You have to find the right person. But I just wanted to tell you that. All right, so that was fun. Of course, I poached a soft sit just as an appetizer. That was a fun clip too from Van Valiant. That was an old clip. It was new to me and it was new to him because he just posted it. But that was fun to see. And then I've had a brand new Judge McBurney and a judge who's made a second appearance, Gettler the bow tie judge. All right, thank you all. That was a lot of fun, and I plan on putting together a Friday happy hour as usual. So I will see you all soon.